Okay, hello again, everyone. We're back again, and today my guest is John Harris. He is the president of the Tennessee Firearms Association here in Tennessee, and I invited John on to join me today to talk about the issue that just became law here in the state of Tennessee. Is what the politicians love to spin it as constitutional carry, and let John talk about that and tell us what we really have here. So with that, John, the camera's yours.
Very good. Thank you for inviting me today. And where I want to start is with this initial question of what is constitutional carry? What, if we're going to discuss that, let's define it. From the perspective of the Tennessee Firearms Association, constitutional carry is a situation where anyone who can legally possess a firearm can carry that firearm without the need or necessity of a permit or even a statute that says it's not a crime to carry a firearm. So constitutional carry is going to be an environment where the conduct, carrying the weapon with the intent to go armed, is in and of itself not a crime under the particular state's laws. I've been a practicing attorney here in Nashville now for 36 years. When I started practicing, we had laws on the books that made it a crime for people to carry a weapon in public with the intent to go armed. Those laws have been around pretty much since the early 1800s. I'm not going to get into why they exist, but they've been there for a long time. Those laws are still on the books today. Today, if you want to see it, you go to Tennessee Code Annotated 39-17-1307, subpart A, subpart 1, and you'll see language that says it's an offense for an individual to carry a firearm with the intent to go armed. And that's still the statutory structure that we have. And what we have in Tennessee, even with the permitting system that we've had since May of '94, is we have defenses or exceptions to the crime. And so when they passed the permit law initially, it is written in such a fashion under the next code section, 1308, that says it's a defense to prosecution under 1307, the crime of carrying with intent to go armed, that someone has a handgun carry permit. It's also a defense, by the way, that you're at your home, and people don't realize that. I mean, you could be charged for carrying a firearm on your own property with the intent to go armed, but there's a statutory defense to it. The permit is a defense. This year, we've seen a 2-year battle with the legislature and the governor trying to propagandize the people of Tennessee by telling them that Bill Lee was going to introduce and as a governor's bill support constitutional carry in Tennessee. And that's just hogwash. What the bill does is it creates under 1307 subpart G, it's a new subpart, a new exception to the criminal charge of carrying with the intent to go armed. And that particular exception that they've created that just went into effect July the 1st has 7 conditions that have to be met in order for someone to have the ability to rely on this new defense. And it's a lot more hurdles to jump through on a day-to-day basis than having a permit. But either way, this is what it's important for people to understand. If you're out in public carrying a firearm, let's say you've got it holstered and it's visible, and a police officer sees you under current Tennessee law in public carrying a firearm with the intent to go armed, that is a crime. Those are the only 2 elements to that crime. The officer has the right to stop you and do an investigatory stop, basically to find out why you're carrying in public, and are there facts or are there circumstances that give rise to a possible defense in order for him to make a decision in the officer's discretion whether or not to charge you with a crime. One of the defenses, as I said earlier, is that you have the handgun carry permit. And so long as you're in a place where you can go with a handgun carry permit, most officers will stop the inquiry right there. They may call it in to see if it's been revoked, because these things, they can last for 8 years or up to a lifetime. But the officer is usually going to stop with just seeing the permit, or at least validating it's still in good standing. Under the governor's new bill, what the governor and some legislators are mischaracterizing as constitutional carry, there's at least 7 elements that you would have to be able to convince an officer on the street, if you were stopped, that you meet all 7 elements. And the officer gets to stop you and make inquiry about those elements. They're the issue of, are you 21 and up? If you're not 21 and up, but you are 18 to 20, then the officer has to inquire as to whether or not you're currently in the military or the reserves, or whether you've been honorably discharged from the military or the reserves in that age bracket. The second question is it a handgun? And what a lot of people don't understand or may not appreciate is Tennessee has a definition of a handgun that's different from the federal definition, because Tennessee has a definition that includes a maximum barrel length of 12 inches. And there are, in fact, handguns out there, primarily guns developed for sportsmen to hunt with, or long-range shooters, that have barrels that are 14, 16 inches or longer. Mm-hmm. And you could not carry one of those either under the handgun permit or the permitless carry. The third element is that you're in a place where you have a legal right to be. We've looked at that language. We don't have any idea what that means. We've asked the legislators during session to explain what they thought that meant. They never gave us an explanation. If you listen to the legislative debates, they don't discuss this third element. The fourth element is that you can't have a prior stalking conviction. In Tennessee, that is very curious, because stalking convictions in Tennessee are misdemeanors, and they're nonviolent misdemeanors. And this is the first time we've seen a Second Amendment right, a constitutionally protected right, impaired by a nonviolent misdemeanor as a result of state law. The third element is whether or not you have DUIs within certain time frames, 1 in the last 5 or 2 or more in the last 10. The sixth element is whether or not you have an adjudication of mental health impairment. And the seventh element is, do you meet all of the qualifications to be able to purchase a gun under federal law? Now, my point in going through all of that is not that you need to remember it right now, but if you get stopped by an officer carrying a gun with intent to go armed in Tennessee and you don't have a permit, the officer has the discretion to ask you for identification, to detain you, and to go through a background check right there, at the patrol car or on the street. Call it in, get all of this information, run your record. Do you have a conviction? Do you have DUIs? Have you been adjudicated? All of that information is within the officer's discretion to detain you until they've checked you out, so to speak. And if you don't check out, they can charge you with a criminal act of carrying with the intent to go armed. That's why we say in Tennessee Firearms Association, this is not by any stretch of the imagination constitutional carry that's been enacted in Tennessee this year. This is nothing more than a qualified defense to an existing criminal charge of carrying a weapon illegally in Tennessee. And if we want real constitutional carry, we quite simply just delete that criminal charge. We can delete one single sentence and get the state to constitutional carry. And instead, these legislators danced around with their governor and created this qualified defense with all these conditional elements in it.
Yes, and as we were talking before we went online here, even with constitutional carry, I'm not even sure that a lot of people realize that you can't carry with constitutional carry, what they call constitutional carry. You can't carry in a park.
But that's correct.
But you can with permit, correct?
We have a number of statutes in Tennessee. We've got the statute 3917, 1307. That's the general prohibition. Okay, that's been around for a long time. And then you need to understand structurally what Tennessee did back in 1989 when they rewrote the criminal code. Back then, carrying a weapon in public was a Class C misdemeanor. It was a $50 fine or 30 days in jail. For most people, it was a speeding ticket, basically a $50 fine. But then the legislature back at this time frame decided, well, wait a minute, if you're carrying in some public places, buildings where they have courtrooms, school grounds, in restaurants where alcohol is served, in stores where alcohol was sold, or in public parks, recreational facilities, or civic centers, that if you happen to be in any of those places with a gun, the penalties, the crime was a lot higher, all the way up to a Class E felony if you were in the courtroom or on school grounds. And so when they passed the permit law back in 94, they really haven't gone back and addressed these prohibited locations at all. They did repeal the restaurant carry law by and large in 2010.
Right.
They have made the courtroom law even worse than it was originally. They did that in 2017. And then you've got these other statutes. Now, what happens is what they have done from time to time is like public parks you just asked me about.
Right.
In 2008, it literally took us 14 years to get to this point. From 94 to 08, we were finally able to get the legislature to put a provision in the parks statute that said it's a defense to carrying a weapon in a public park, on a greenway, in a public campground, any kind of public outdoor recreational facility. It's a defense to that if you have a permit. Now, when they ran this governor's bill this year, we said, hey guys, you're omitting a bunch of stuff. It's an incomplete task. You're screwing it up. Here's some things you need to think about. One of those things was public parks. This was specifically brought to the attention, not just of the bill sponsors, Representative Lamberth and Senators Mike Bell and Jack Johnson, but we mentioned this to a lot of other legislators as well. And they made the choice. It's not like they overlooked it. They made the choice to not include for permitless carry the capacity to carry into a park, in a greenway, in a campground, or those kinds of locations, which means if you think you can stroll into a public park under this new permitless carry law that just passed, you're going to get charged with potentially one, if not two, criminal charges. One for carrying in a park, and another maybe under that 1307 language that says that you have to be in a place where you're legally present, because I could see an argument that you're not legally present in a park with a gun unless you have a permit.
Right.
And there's actually about 9 of those situations under very specific sets of facts. The one that I think most people are going to run into is public parks and greenways. And you got to sit back and scratch your head and say, wait a minute, how can this even be credibly called constitutional carry if I can't go in a public park? Think about it. 1/3 of the state of Tennessee is basically a federal park called the Smoky Mountains.
Right.
It's off limits. You can't go there with permitless carry under the governor's law and the way they wrote it.
Or if you're camping or whatever, if you take your family down to one of the local state parks for a weekend camping trip and you take your weapon with you, if you don't have a permit, you're committing a crime.
Absolutely. I think you can easily be charged with that.
Yeah. Wow. And like I said, I don't think a lot of people were aware of that. Also, my fear is I want constitutional carry. I mean, flat out true constitutional carry. But for folks who have permits, my fear is that they will give up their permit and don't realize what they're doing. Like if, let's say you go to a state that doesn't have constitutional carry, you're going on vacation and you get stopped in that state and you have a weapon, you don't have a permit. They have an agreement with Tennessee to recognize their permit, but you don't have it.
That's correct. The last time I
Money.
checked, which was yesterday,
Yeah.
the Tennessee enhanced permit is recognized, I believe, by 38 states. The Tennessee concealed only permit, and let me say, as an aside, that was an abrogation. They never should have passed that. It was a misdirection, just like calling this one constitutional carry. But the concealed only permit that Tennessee adopted that became effective July 1 of 2020, I think is only good in 36 states. So if you want to carry in another state, the safest mechanism for doing so is to have the Tennessee enhanced permit. Now, I will say, matter of fact, I was talking with a law professor who teaches Second Amendment law, and he's a professor in North Carolina. I was speaking with him Tuesday night, and so there are some states which have laws that allow permitless carry within that state and don't require that you be a resident of the state. For example, Tennessee's permitless carry law does not apply just to Tennesseans. So someone from another state could come here and operate under that law, and if they can meet all the standards, they get the benefit of the law. Other states have that same kind of law. So even if you don't have a permit, there may be a few states that you could go into and get away with carrying in those states. But it's a network and a nightmare to try to figure out which ones they are, and is that law still on the books, and how do you get even from this state to that state? And the permit is the easiest, cleanest way to get the ability to carry in other states under current circumstances.
Yeah, that was my next question is, how would it affect people, say like someone from Indiana coming into Tennessee who didn't have a carry permit, but they heard that Tennessee was a constitutional carry state. So basically the law is going to affect those people from out of state, just like it does the residents of Tennessee. Is they have to meet that seven questionable things to be good, right?
Oh yeah, it's like Nazi Germany. Officers see someone on the street that walks up and say, show me your papers. And they can hold you for 10, 15, 20, 30 minutes until they run that check. But you're right. When the bill was initially filed in February of 2020 by Bill Lee, it was restricted at that time to Tennesseans only. It wasn't available for everybody. Between February of 2020 and all of COVID happening for whatever reason, and what they filed this year when they refiled it, they took out the restriction that you had to be a state resident. So what is on the books now would apply to a resident from any other state that's legally in possession of the handgun here in the state, and they can meet all the other qualifying conditions that were put into this new law.
One of the other things I wanted to ask you about, I think it was Tuesday, federal court ruled that it was illegal against the Second Amendment to ban people from 18 to 20 from owning firearms or purchasing firearms. And I do know when this bill that they passed went into effect in July, that people from the age of 18 to 20 could not carry under this. So how would this court ruling kind of affect this, or does it?
It potentially does, and let's unwrap that a little bit. As I mentioned earlier, there is a 21 and up provision under the governor's law. There is a provision that says, has to do with people in military service or retired. So let's set those aside, but let's just take your average 18 to 20-year-old. They're not entitled under the governor's law, even though we argued otherwise. And even though there were two bills filed by House and Senate members that would have said 18 and up. Okay. The governor's bill stayed at the 21 and up standard. And within about 3 weeks of the time that the governor's bill was actually signed into law back in April, a federal lawsuit was filed in Knoxville, Tennessee. The case is called Bassett, and it's filed by 3 19-year-olds. And they have sued the state of Tennessee, claiming under the Second Amendment and the 14th Amendment that their civil rights are being violated by this new law because they're being treated differently. They don't have equal protection and due process to be able to carry a gun in that age bracket, whereas other 18 to 20-year-olds can. And they also argue that the Second Amendment rights attach at age 18, not 21. Now, that case, I don't think has moved very far at this point, or the last time I checked, it hadn't. But that's going to raise this issue directly. And because it's brought as a civil rights action, if they're successful, the citizens of the state of Tennessee are going to be held responsible potentially for their legal fees.
Mm-hmm.
Okay. Now, that's the Bassett case. What we saw on Tuesday of this week was a decision that came down from the Federal Fourth Circuit Court of Appeals, which is not Tennessee. Tennessee's in the Sixth Circuit, in a case called Hirschfield. And the Hirschfield decision is a little over 140 pages. It's extremely detailed. But what the court in Hirschfield said, this federal court, is that the right to keep and bear arms at the time that the Constitution was enacted and for decades after that clearly applied to anyone 18 and up. And they gave a lot of reasons for that. One of which was, for example, that the duty to respond to a militia call that existed not only then, but still exists today, attaches at age 18. And that duty, if it was imposed, required that those 18-year-olds, and does require that they respond to the militia call adequately equipped for military service, which the court said clearly includes the obligation to show up with arms. I mean, the very preamble to the Second Amendment talks about the well-regulated militia being necessary to the security of a free state. Right. So what the court in this Hirschfield Fourth Circuit case said is that the right, this under the Second Amendment, although it may even attach earlier than 18, because in some states at the time of our Constitution, the militia age was 16 and not 18. Right. But it was clearly at least 18 in every state. The court said if the Second Amendment right attaches at 18, then Congress, when they enacted the 68 Gun Control Act, which has been on the books now for 50 plus years, and it's the law that says a gun dealer cannot transfer a handgun or handgun ammunition to someone 18 to 20 years old. The Fourth Circuit said that law, that restriction with respect to that age bracket is unconstitutional because it impairs and infringes a right held by those people that is protected from infringement under the Second Amendment. And I think it's also, and the court picked up on this, important for people to understand that while someone 18 to 20 years old can't go into a licensed gun store and buy a handgun, both state and federal law allow people 18 to 20 years old to buy handguns and to possess handguns as long as they buy them from another individual in what's called a casual sale, or they may inherit it, or they may receive it as a gift. There's a lot of ways 18 to 20s can come into legal possession. They just can't buy it from a dealer.
Right.
And so the court picked up on that and said, look, Congress didn't say 18 to 20s can't have them. Congress said federal dealers can't transfer to them. And that's a substantial observation that the court made. And then to go back to your question, if the court's Fourth Circuit ruling that 18-year-olds are vested fully under the Second Amendment, then I do believe that Bassett case in Knoxville is much stronger. I also believe that the structure of the governor's bill, because there's no severance clause in it, it may render the entire bill itself that it was enacted this year unconstitutional, which means this entire permitless carry law could be stricken from the books by a federal court at some point in the future.
Yeah, and that could have been fixed by simply just doing true constitutional carry.
Absolutely. If they'd have deleted that one sentence, one sentence.
And I know you folks at Tennessee Farms Association have really worked hard on that. There was some out-of-state help as well. And, you know, I know there was a lot of good people who tried to talk to these legislators about this and done no good. And basically, some of the legislators actually attacked good people for bringing up the issues that were attached to this bill. So, you know,
There's no doubt that they did. And let me mention that for a minute, because people on social media, I think, need to be aware of some facts. You know, the devil's in the details. And that was no pun intended. TFA took the position, and we have for more than 2 decades on this issue when it comes up in Tennessee, that the Second Amendment prohibits permitting requirements, and it attaches at 18 and up, and it attaches to any firearm, not just handguns.
right.
This year and last year as well on this issue, and in prior years, TFA was joined by Gun Owners of America on that issue, National Association for Gun Rights on that issue, Second Amendment Foundation on that issue, and then the Bassett case that's been filed in Knoxville has been filed with the financial support and with attorneys hired by, as I understand it, the Firearms Policy Conference. There's one national organization that stood against your rights in Tennessee under the Second Amendment for real constitutional carry, and that was the National Rifle Association. They opposed true constitutional carry in Tennessee. And let me give you a little bit of the details why. The NRA has a part-time lobbyist. The lobbyist that's in Tennessee covers, I think, 4 other states. The NRA hired their lobbyist in Tennessee directly off of Bill Lee's staff, his governor's staff. So this isn't someone that had worked in the trenches as a strong advocate at the grassroots level for Second Amendment for many years. This person was hired right off of the governor's staff. And it's worse than that. One of the biggest victories TFA and gun owners had in removing, I'll just call them rhinos, from the legislature was back in 2012 when we went after Deborah Maggart, who was the number 3 House Republican. At that time, she was defeated in the Republican primaries by Courtney Rogers. And in fact, not only did TFA weigh in on that battle, but so did the NRA and NAGARD, National Association for Gun Rights. Your listeners may be interested to know that the individual that was on Deborah Maggart's campaign staff back then is currently the NRA's lobbyist.
Wow.
He was also on the campaign payrolls for currently Senator Shane Reeves. He was a campaign worker for Lieutenant Governor Randy McNally. He was a paid assistant for former Senator Jim Tracy. And before he went on to Bill Lee's governor's staff, he was the Senate Republican Caucus Communications Director. And some people prefer to call it propaganda director, but that's the role he's held. So for 10 years, roughly, this guy has been an insider with the Republican Party that's in control of the General Assembly.
Right.
And you got to step back and ask yourself, is someone like that, do they have the capacity to hold legislators accountable in the next election cycle who refuse to support true constitutional carry?
No.
And I'm not going to answer that question. I just want to put that question out there and let people who are listening to us ponder that.
Right.
But the only national entity, the only entity really that, other than Moms Demand Action and Bloomberg and Soros funded groups, that really opposed real constitutional carry and preferred the governor's permitless carry disaster was the NRA.
Yeah. Well, I've known for years, and if people would do their research, they NRA will compromise your rights away. They've done more damage. Listen, I'll just put it this way: when they give Harry Reid, former Democratic Senator Majority Leader Harry Reid, an A rating uh, on gun bills backed by the NRA, then there's a problem, and you need to do your research on them. And I believe people would be surprised. There's a reason why they're having financial issues now. So,
well, there he is. But the point is, as your listeners, as the people that are going to listen to this down the road, receive the information and they go talk to their legislators, they may hear the legislators respond back. Well, the NRA supported the bill. Well, the NRA wrote the bill. Well, the NRA told us this was a good bill.
mm-hmm.
You know, you look at the history of the NRA's lobbyists, that could just be, you know, a double agent, so to speak. Was he really fighting for us, or was he hired by the NRA to facilitate cover for the establishment Republicans in Tennessee?
And that happens all the time. Yes, sir.
Like you said, compromising rights away.
Yep. Big time. So take a few minutes and tell us about Tennessee Firearms Association here in Tennessee, and where people can find you on social media, websites and stuff, if you don't mind.
Sure. Tennessee first adopted a permitting system in May of '94. TFA was formed in '95 initially because we realized immediately that although they had adopted a permitting system, the state legislature had failed to address this patchwork of other laws that made it impossible once you had a permit to practically go anywhere. You couldn't carry in a grocery store, a public park. You couldn't carry almost anywhere. You could drive down the road with it. And so we were formed in '95. We're a nonprofit corporation. We're a 501c4, so we're not a charity, where what's the IRS identifies us as a public benefit organization that's subclassified as an issue advocacy group. We advocate for a particular issue or against bad legislation. And so unlike the organization we were just discussing, all of the officers and all of the board members of the Tennessee Firearms Association are volunteers. I've actually served as its executive director now for 26 years in a just donated time capacity. And our focus is to work on and try to improve legislatively laws in Tennessee. But we've realized that, for example, for years, we accomplished stuff with the Democrats in control. And then the Republicans were the minority party up until 2010, and they kept promising us, hey, help us get control. We're more Second Amendment friendly. And so we did, in fact, work with the Republicans because some of those guys they were some of our best advocates in the General Assembly. But what we've seen is, even though they've had control since 2010, we've gone backwards in some respects, and it's because, and this is why we went after Deborah Maggart. We were specifically told once the Republicans got control that they wanted super majorities. And the only way for them to get super majorities was to move left and to try to pick up the moderates and the independents. And so they weren't going to forcefully pursue true Second Amendment issues because they wanted power more than constitutional stewardship.
Right.
And we've seen that problem. And so in the last 10 years, TFA has increasingly engaged with its PAC in the Republican primaries, which are in August, to try to replace incumbent legislators in both parties with candidates that we think are more constitutionally focused. We have started engaging in litigation. As a matter of fact, in the last 5 years, TFA has been an amicus party in 2 cases that went all the way to the United States Supreme Court. And all of that's done with volunteer labor and effort. And we're able to do a lot of that stuff because TFA is a membership-based organization. You can go on our website, TennesseeFirearms.com, and join. And you can join today for $35, which is the exact same amount that it was when we started in '95. And the money isn't going to pay someone's $1 million plus salary or put them on private jets. It's staying in Tennessee to work for Tennesseans. And then we do have the Political Action Committee, which is a separate entity, and people can support it as well. And as a matter of fact, the Political Action Committee, TFA LAC, has its big annual fundraiser, which is a barbecue luncheon and auction. This year, it'll be on September the 4th at the Farm Bureau Expo Center in Lebanon, Tennessee. But they can go to tfalac.org and buy tickets or become a sponsor of the event and help us raise money that we need to support the candidates that we think are going to move Tennessee towards a more constitutionally responsible legislature.
Great. And yeah, and sign up for the emails too. And
absolutely. The emails are free. You don't even have to be a member to get the emails. Right. You can also go on our Facebook, just Tennessee Firearms on Facebook. You can join the group and you don't have to be a member to do that. And if you have a question or a comment that's relevant to Tennessee and firearms issues, that's the place to discuss it.
Yeah. All right, John. Well, I thank you for joining me today. I think you gave us a wealth of information and covered a lot of stuff that people didn't realize. So I know we're going pretty long here, and that's fine too. But I know you're a busy man, and it's still early evening in Nashville, and you may have some more things to do. So we'll cut this off here. And like I said, I appreciate you taking the time to inform the people of the state of what's going on, and hopefully they'll look to your organization for guidance and information on gun legislation here in Tennessee.
I do appreciate the invitation today and the opportunity to discuss this. And I hope that this gets a lot of viewing and reception, because one of our goals right now is to make sure people understand that they should not trust this new permitless carry law if they want to carry a firearm in Tennessee. They just need to go ahead and get their enhanced permits, because this new law puts them at risk for criminal prosecution.
And that's what I would ask as well. Please take time and share this with your friends and your family that that value the Second Amendment, and share it with them, because I believe it's great information. All right. With that, we'll say goodbye, and we'll catch you again. Have a good one.